In your work/mission in environmental protection, you can keep in mind that a very good and efficient tool that you can use is environmental law. International environmental law is a branch of public international law which regulates the relationship between man and the environment. The legal regulatory framework includes domestic laws and international agreements. The term multilateral environment agreement relates to a number of legally binding international instruments used by states to engage in the achievement of specific environmental goals. Different types of agreements have different legal mechanisms to ensure environmental protection. They can be classified into two groups. Prohibition, restriction, standards. The activity or product is generally prohibited. Approved procedure. The activity or product is generally allowed. The Constitution is the fundamental law which sets the legal norms for the environment protection, rights, and responsibilities of the citizens. Environmental law is the set of legal norms that regulate human relations with the environment. The law on environmental protection forms the basis of environmental legislation, defining the general principles for the purpose to protect, preserve, improve the environment, and the quality of life. The law on public information and consultation provides for the rules and procedures for conducting public consultation and public participation in policymaking and decision-making processes. The law on environmental impact assessment provides rules and procedures for the prevention, minimization, and compensation of damage to the environment. The law on the protection of conservation of wild fauna aims to protect, to manage and control the wild fauna with the aim of preserving the species, populations, habitats where they live. The law on biodiversity protection aims to ensure the protection and conservation of biological diversity. The purpose of the law on protected areas is to provide special protection of environmental protected areas and important components of biodiversity and nature in them. The objection starts following the steps of the administrative appeal, which includes written correspondence with the decision-making authorities. The first step is the collection of preliminary information. If the information is submitted and a violation is found, then is proceeded with the appellate court. When the information is delayed or rejected, it can be proceeded with the administrative appeal or an appeal to the commissioner who takes the decision for 15 days. Or a court appeal can be filed against the institution. Once the information is received, the court case can be opened. After following the administrative appeal procedures, the legal action of the administrative court appeal against the other party is undertaken. The team of lawyers, after collecting and administrating the facts and evidence, can file a lawsuit in the administrative court. With the filing of the lawsuit, the following is done: drawing lots and determining the trial panel, and notifying the parties and scheduling the preliminary hearing. From the court session in the first instance, we can have non-final decisions that are the termination or non-acceptance of the lawsuit, and final decisions that include the full or partial acceptance of the lawsuit or the dismissal of the lawsuit. After the final decision from the first instance, one of the parties that does not agree with the decision has the right to appeal to the Administrative Court of Appeal. After the final decision by the Administrative Court of Appeal, one of the parties who does not agree with the decision has the right to appeal to the High Court. It is very important that at this stage the preliminary information is collected, which in the case of the development project with public-private partnership includes the concession contract and all the accompanying documents of the standard procedure, environmental impact assessment report, additional documentation, the most important conventions related to environmental issues. The Aarhus Convention is a new type of environmental agreement. It is based in three main principles: access to information, access to decision-making, access to justice. The convention has a special grievance mechanism called the ACCC Compliance Mechanism, which can be used by the stakeholder public, which can be a state, a group of NGOs, an NGO, or even a single citizen. The ASPU Convention sets out the obligation of states to notify and consult each other on all projects under consideration which may have an adverse environmental impact across borders. The public and NGOs can be involved through participating in the environmental assessment of projects that have cross-border impacts according to the EIA Convention, Participation in the environmental assessment of plans according to the SCA Protocol encourage their government to ratify and fully implement the Convention and the Protocol. The Berne Convention, signed by the European Union and 51 countries committed to protecting wildlife, both species and their habitats. As soon as an NGO or private citizen finds a possible violation, they can file their complaint, which can be processed by the Secretariat or the Bureau, and when it is of special importance, by the Standing Committee. The 1989 Basel Convention is the most important legally binding international agreement on hazardous and other wastes. This convention sets out a complaint mechanism which can only be used by a party regarding implementation and difficulties of compliance, known as the self-surrender of the party, a party with respect to the implementation and compliance by another party with which it is directly involved under the convention, the Secretariat of the Basel Convention. The Helsinki Convention is the convention on the protection and use of transboundary watercourses and international lakes. This convention sets out a grievance mechanism which can be used only from one state to another or from several states versus another. It is very important for your organization to understand the conventions and the law. To help you build a successful litigation strategy, in the description you can find a more detailed manual.